Welcome to our podcast, Was Justice Delivered? Your go-to source for interesting, provocative, and in-depth legal analysis. I'm your host, Dror Bikel. We are so pleased to welcome the Honorable Rosalyn Richter to our podcast. Judge Richter is one of the most respected attorneys in New York State. She is a former Associate Justice of the Appellate Division, First Department, one of the premier intermediate appellate courts in the United States. In that role, she presided over a diverse range of complex issues, including criminal and matrimonial matters. Before joining the appellate court, Judge Richter served as a trial judge for 19 years, overseeing criminal, civil, and family law cases, including matters that involved allegations of domestic violence. As a scholar and leader in the legal community, Judge Richter serves as an adjunct professor at Columbia Law School. Judge Richter also represents victims of domestic violence in court pro bono, meaning for free, for the organization Sanctuary for Families, New York's leading service provider and advocate for survivors of domestic violence. Judge Richter is currently senior counsel at the law firm Arnold & Porter. Judge Richter, welcome to our podcast. Was Justice Delivered?
Well, thank you so much for having me. It's a pleasure to be here, and I look forward to our conversation.
Judge, how did you get into being a judge? Just tell us a little bit about your background.
So, when I got out of law school, I first went to work for a very small family law firm that I had worked in part-time while I was in law school, and then my boss closed the firm, and I had to find another job, so I went and became head of an organization that's now very large, but then was tiny, Lambda Legal Defense. I was there a number of years. I took some other jobs. I'll skip through all of that. And then I began to sort of think about how do you become a judge, because I was in front of judges and I had an opportunity to be an administrative law judge full-time for a New York City tribunal. And I took that job sort of thinking, well, I'll see how I do as a neutral. I loved it. And then Mayor Dinkins became mayor of New York City in 1990. Most of your listeners, or many of them, probably don't recall Mayor Dinkins. And people sort of said to me, why don't you apply? And I didn't really expect that it would happen quickly, but it did. And I was in the very first group of judges appointed by Mayor Dinkins to the New York City Criminal Court. And that's where I started my career. And relevant to this podcast, as I'm sure you know, many, many domestic violence cases come into criminal court. So I was exposed to the issue sort of significantly in my early years as a judge.
And after you left the criminal court, you were in the civil court and you presided over matrimonial cases, which also has a fair number of domestic violence cases.
Absolutely. So I spent a couple of years in Manhattan and then became the supervising judge of Bronx Criminal Court, where I helped set up an IDV part, which I know we're going to talk about what that is. Then I got elected to Supreme. For your listeners, judges in New York, depending on what court they're in, some are appointed, some are elected. But to get to Supreme, I had to be elected. And then I moved over to the civil side, where among the many assignments I had, you are correct, I sat in a matrimonial part, which here is divorce cases for people who don't know what the term matrimonial part is.
Right. And then from there, you went on to the appellate court for many years.
That's all correct. Right. Then the appellate court, just, again, each step of the way is a different process, was a governor's appointment, and I was appointed by David Patterson.
Judge, let's go back to your experience presiding over criminal cases. What was unique about these domestic violence cases?
Well, I think, whether it was criminal or civil, the fact that the parties were connected, the fact that there were often children involved, the fact that there was extended family, friends, religious clergy. Lots of people had involvement, even just indirectly. I don't know, if you have a shoplifting case, you don't have the relatives of the Dwayne Reed or some other drugstore owner or the person who was arrested. Maybe the family of the defendant is concerned. But in the domestic violence arena, you have all these connections that influence how everyone approaches the case. And that just makes it complicated.
And were these connections witnesses during the hearings, or were they just interested parties who were there?
Well, so I think the first thing is, for those who don't maybe know, you do, but for your listeners who don't know how a criminal case works. So the first stop or the first step is an arraignment. That's the initial court appearance, where the prosecutor indicates what the charges are. The question of bail or no bail may come up. An order of protection is often requested. And at arraignment, sometimes the complainant, also known as the victim or survivor, might be there wanting to drop or lower the charges. Sometimes the family was there with a different version, or at least perhaps offering some insight into what had happened. Some were witnesses. I mean, not always, but that was just a unique factor in these cases that had to be accounted for at the very first court appearance.
Yeah, that's so interesting and not uncommon, both from my experience as a practitioner, the idea of pulling back.
Right.
Making those initial allegations, going to court, retaining a lawyer, or going to the district attorney's office, and then feeling bad, feeling that, let's just say it's a woman, feeling that she feels guilty and feels bad for the perpetrator and pulling back. Is that something you saw frequently?
Sure. It doesn't mean, or did not mean, that the incident didn't happen, but the reality, particularly, if you took the typical case, you were right, statistically more often it is the woman who's the victim. Doesn't always happen, but it's statistically true. The children may already have been begging their mother not to keep their father in jail. She may have heard from the grandparents or the siblings or the local clergy. It's a very significant decision to have someone arrested. And then, what the person wants is for the violence to not happen again. And so there are economic consequences of someone going to jail. They're the provider. Suddenly the reality of what's going to happen if they're not working, who's putting food on the table, rent has to be covered. So I think that's what's unique about these cases, is someone's whole life is involved in the decision to prosecute.
What was unique in terms of the hearings? So, you preside over a trial, and I know the burden of proof is different in the criminal courts and the civil. Criminal is beyond reasonable doubt, and in the civil, it's preponderance of the evidence. More likely than not, the 51%. Right. But when you're sitting there on the bench, Judge, and you're hearing testimony, what are you listening to? What's important to you?
Well, certainly all judges consider what we call demeanor. In life, we all make a lot of decisions based on how someone sounds, but also how they look, how they present. Have they told the same thing to different people? So in these cases, if there was an arrest, and there's not always an arrest, but if there was an arrest, there's usually a police report right on the scene. So you do look at what is the first thing the person said, before they thought about it. And you're also looking at medical records. Again, not everybody goes to the hospital, but certainly we'll take the easy case. If the person has marks around their neck indicating that someone tried to choke them, and there are pictures taken at the hospital, and then the person, the other side, comes along and says, no, she fell into the couch. As a judge, you're going to want an explanation for those medical records and the pictures, and how does someone get choking marks when they say the other side says they fell into the couch? So that's a fairly typical case. Or maybe there's a contention that she choked herself. That certainly I heard that. And you have to ask, why would someone choke themselves? It's possible, but
not likely. Yeah.
Yeah. Those are the kind, you're really looking for certainly objective verification of what one side is saying, although you don't always have that.
Yeah, so what happens when there's no objective verification or some sort of contemporaneous statement or police report? So you have the case where the victim, let's use the word victim because I know that a lot of victims like to call themselves survivors, understandably. The victim did not tell anybody, did not call the police, there's no marks, but claims a history of hair pulling and, spitting and kicking and that kind of thing. So at that situation, I guess the credibility of the witnesses, it boils down to that.
It certainly does. But sitting here today, I can't recall cases in which there was a history and no one told anyone. Usually there's someone, first of all, the neighbors. If the fighting's bad enough, the neighbors have called 911. Or the school is reporting that the child is coming in and misbehaving, or child welfare has gotten involved. People do confide in someone often. They may not confide in law enforcement. And you're just looking for sort of other signs, and I mentioned some of them. What is the impact on the children? So if someone is saying, no, everything's perfect here, well, then you want to know sort of why are the kids showing up, and crying in school. Also, in divorce cases, again, often, not always, there'll be what's called a forensic exam, which is, as you know, a mental health professional who has spoken to the parties, spoken, if the children are old enough, to the children, and spoken to what we lawyers call collaterals, which are just other people in the kid's life. And you often get, again, information from them that helps you understand what's going on in this dynamic.
How do these allegations of domestic violence affect legal custody? So, you have a situation when, now putting on your hat as a judge in the matrimonial courtrooms, which you did for many years, you have allegations, and, frankly, there's often cross allegations when it comes to domestic violence. But let's say you have some allegations of domestic violence. What happens to the children? How does it affect custody?
Well, first of all, the law now, since I left the trial court, there was case law, but now there's a statute, a law, that requires courts to consider allegations of domestic violence and make findings, so specifically address it. Exposure to domestic violence, any kind of violence, impacts children. The social science, mental health studies are clear about this. It's not definitive that someone can't get custody if you find these allegations truthful, but certainly it's something that has to be addressed. It's a legal hurdle, and someone can get time with their children, often initially depending on if it's severe violence, in a supervised visit setting. And you often find that children who've witnessed violence, particularly young children, are afraid to spend time with the parent who's the abuser. So that's what supervised visits does. That's what counseling does. There's no one-size-fits-all ruling, but it has to be addressed.
And Judge, if you're presiding over, and let's talk about a divorce case where you really feel, based upon what you've heard from the lawyers, some of the evidence you've seen, that there are allegations of domestic violence. There's real it's more than allegations. You really believe, without having an evidentiary hearing, but not believe, you're suspicious that it's real. But one of the parties is really refusing to pursue it. Is there anything you can do? And you're in a tough position because you're a judge, right? You're not an advocate.
Right.
Now you are an advocate in your role now.
But I wasn't.
You weren't back then. So is there anything you can do? Is that appropriate at all?
First, it's a great question. All of these are great questions and complicated. So in a criminal case, if the complaining witness drops the charges, the prosecutor has to decide whether he or she can prove the case without the complainant. Sometimes they can. Sometimes they go ahead with medical records, photographs. In the civil case, the state is not a party. So if someone wants to, for example, drop their divorce case and reconcile, that's their decision. I think you have to rely on, in a contested custody case, everyone has lawyers. If they can afford lawyers, they've hired them. If they qualify for what's called 18B, court-appointed counsel, because they're legally indigent, then the court has appointed them. So you just want to make sure as a judge, one, that their lawyer has fully explained to them all the consequences and risks of what they're doing. As a judge, depending on the case, I might want the parties to come to court so that I can ask them questions under oath to make sure no one's threatened them, that they're doing this voluntarily. And also, and it might surprise your listeners because it surprises a lot of people I talk to, the children most likely have their own lawyer. And so you also sort of want to make sure that, someone is in immediate danger. Then there has to be a notification, not by me, but by someone else in the case, to child welfare. If someone is really returning to a dangerous situation, putting children at risk, then the state gets involved.
Did you see, in your experience as a judge, differences in socioeconomic status as it relates to perpetrators and victims of domestic violence? I think statistically, it's actually pretty even, but I'm just curious, as a judge who presided over these cases for so many years, whether you saw a difference.
No, I saw people of every economic level. I think there's some belief that this doesn't happen in sort of middle and upper middle class families. That's just not true. I think what you do see is that the economic pressures to stay together are greater for people who have less income. If you've got a significant income or significant savings and you want to leave and you have the money in New York City sort of for, first month's rent, last month's rent, moving expenses, at least economically, it may be easier to leave. It may not be any emotionally easier to leave, but you may have more choices economically than someone, let's say, where the victim's not working at all. But there are also many agencies, Sanctuary, and there are many others where they can help with not direct financial assistance, because they don't do that, but they can help the person with getting on public assistance and getting access to other benefits, grants, things like that. And of course, there are shelters for domestic violence victims and their families, for people who really don't have other housing options. So I think the issue is connecting people to resources, and those who already have resources are in a better place.
What happens, Judge, when a party comes to court, and now you're a divorce judge, and there's an incident that happens, and they're seeking a remedy from you on an emergency basis? And it often happens in the beginning of a divorce case. Somebody comes to court, seeks an order of protection. What do you do? How do you handle that as a presiding judge, these kind of emergencies that happen?
Sure. As a judge, your fairness and the ability to keep an open mind is sort of part of the job. And so these emergencies, as you know, are brought typically in what's called an order to show cause. That's just a request for emergency action. And assuming it's a case that's already started, the first thing you do is make sure somebody has contacted the lawyer on the other side, and they get a copy of the papers and a chance to respond. It may be respond in writing. If it's really an emergency, you hear them orally. If they want to have a court reporter so that there's a written record, you do that. And you sort of say, this is what this person says. What's your response? What's the other side's version? And, you do have to make a decision. Again, you're looking, is there any, what we call corroboration, any objective proof? And also, maybe you've seen these people already once or twice, so you have a sense already of what's going on, and you try to see if you can find a solution. Sometimes, quite frankly, the alleged perpetrator says, look, I'll leave. I'd rather not keep up this fight. We'll sort it out later in the divorce. Sometimes, not always, and not typically, but once in a while, the victim has already decided to leave. The only question you have to deal with is sort of, how does everyone get to see their children? But you certainly don't want people who are fighting, physically fighting, or even serious verbal harassment to be in the same household and keep it up. It's just not good for anybody.
Yeah, and it can get worse, right? And certainly,
sure,
if it's gotten to the level where you were involved, then it's pretty bad in the home. What sort of legal controls did you have at your fingertips, at your disposal, to ensure safety of the victim and safety of the children? So there's the issuing order of protection, there's supervision. What sort of things did you order to be put in place to ensure everybody's safety?
Well, certainly an order of protection, which is a court order directing the perpetrator to do something. It could be to leave the home. It could be to stay away from the victim's workplace. It could be to meet the children at a police precinct, in front of the police precinct, because every time he or she comes to pick up the children, there's an incident. So you want to figure out where is the point of sort of disagreement. How do you ensure safety? Sometimes you have a third person, a grandparent. I certainly recall issuing an order where the paternal grandmother, both sides agreed, was a neutral. Not always typical, but the grandmother, so it would be the father's mother, the mother of the children,
right,
trusted the grandmother. And so she'd pick the kids up, walk them to the new apartment, bring them back. That doesn't always work, but that worked in that case. In a really severe case, you might be ordering, as I said, a pickup and drop off at the precinct. Not ideal because you're exposing the kids to the police. You can order no contact at all. All of this, of course, is after you've heard from both sides. And sometimes you have to have a hearing. There is a new case that came down after I retired that does require some type of evidentiary hearing, some sworn testimony, if it's requested before you take someone out of their home, if they are the person on the lease or paying for the premises.
Did you ever have a situation where you felt somebody was just being untruthful to you? How common is that?
It's pretty common, or at least half-truthful. Maybe there's some truth in it, but look, it's really hard for people to admit they've done something wrong, whether that's criminal or civil. And so they sort of try to make up a story that doesn't always match the evidence, and you can tell. And, that's a difficult situation. It doesn't necessarily mean they don't get to see their children, but, not being truthful with the court doesn't help the case.
One of our guests, Dan O'Leary, a psychologist, said that this is not an uncommon situation where you have, let's call it cross incidences of domestic violence, where both parties are kind of engaging in domestic violence, pushing, shoving, hitting, spitting, elbowing. But only one party brings the request for an order of protection. And it's going kind of both ways. I know it's a very confusing situation, but I ask you the question because it's not so uncommon. And so I'm just curious, and certainly based upon what Professor O'Leary was saying, is that it's actually, I've forgotten the statistic, but it's actually quite common for that to happen. So as a jurist, how would you, if you can even answer that question, it's a tough question, but how would you handle that situation?
Well, it's interesting. I don't think I saw as many cases of that. I did see cases where someone starts the fight and someone's defending themselves or retaliating, or someone's using physical violence, slams a head in the wall, and the other person spits back or slaps back or yells back. So I think, first of all, you really want to try to figure out who's the instigator, what is the medic. There is often more medical evidence because if people are hurt, they go to the emergency room.
Yeah.
Also, just as an interesting legal point, we all know that when you show up at a doctor or the emergency room, they say to you, "Had that happen?" And people are often surprisingly honest with the doctor or nurse or triage person, even if they're then very soon telling a different story. And those medical records are then presented to the judge in the divorce action, because that's often the first point of contact, because if people have scratches that need treatment or a broken wrist, they don't really think about, I'm going to have a legal case. So those were very helpful in the few cases I had about cross-allegation, because you would get two sets of medical records and could look at what everybody said.
And in terms of the ultimate decision, whether this took place or not, I'm imagining it's really boils down to the credibility of the parties, right?
It does. And also, what are the motives? Sometimes you won't hear about cross allegations of domestic violence until maybe financial issues are at stake, or someone's asking for sole custody. So you do often, as a judge, sort of say, and it doesn't mean it's not true, but sometimes you're sort of looking at the timing of all this.
Judge, what is the integrated domestic violence part?
Sure. So the integrated domestic violence part is one of New York's problem-solving courts. So the idea of it is, you're still operating within the law and the legal system, but it's also designed to address sort of the root of the problem. And it's a court in which if someone has a criminal case, a divorce case, and perhaps also a family court case involving child abuse or child neglect, all of those cases, which ordinarily would be heard by 2 or 3 different judges, are heard by a single judge who can address all of the legal issues involving that family. Unlike other states which might have a single court hearing those cases, New York's court system before the IDV courts didn't allow for that. So for the judge knows what's going on with the prosecution, the divorce, and also the maybe neglect and abuse case, which would have been brought by an agency called ACS, the Administration for Children's Services, child welfare in some states.
And you were one of the creators of let's call it the IDV.
Right. So I was a early supporter. Obviously, I did not come up with this idea. This effort was inspired by a number of people, including now deceased retired Chief Judge Judith Kaye. But I helped found such a court in the Bronx when I worked there on the criminal side. The other thing the court did is that if someone was mandated to attend programs, counseling, violence, anti-violence education, parenting courses, it would help keep track. Is the perpetrator going to all of these services? And it really was very helpful, because otherwise, let's say you're the judge in the divorce case. Yes, you could call or email the other judge, but then you had to wait for the response back, and you had to hope that judge would contact you. And obviously judges talk to each other. We know each other. But this just really allowed for efficient decision-making. And if someone wanted to resolve their case, at least you had the ability, subject to the agreement of the prosecutor, to try to come to a global resolution. It was particularly helpful in cases involving custody, especially of young children, where the goal is to protect them.
Now let's put your appellate judge hat on, because you served for many years as an appellate judge. I mean, it's such an amazing background. What was that like when you addressed these domestic violence cases, both on the civil and criminal side?
Well, certainly it's different, because as an appellate judge, you don't have the witnesses, the parties in front of you. You have what we call a record, which is simply a typewritten transcript, or it's not typewritten anymore, I'm dating myself, a computer-written version of what everybody said and the legal arguments of the lawyers. So there, the judge has already determined credibility, who to believe, who not to believe. Now, we had the authority to overturn that. So there, you're really looking at the evidence. Again, what I mentioned earlier, is there objective proof, medical photos, but also you focused on the law. What does the law say? Did the judge make a mistake? And then you might fix it, or you might send it back to the judge to correct.
Were there many cases that had to get sent back? I'm imagining not, but I don't know.
Not as many as people think. And the issues that went back or we fixed didn't actually have to do with the domestic violence. It often was, a mathematical issue in the calculation of support, or maybe an issue about who pays the legal fees if they didn't have a court-appointed lawyer. And just sometimes it was a judge, and it was rare, who maybe decided something too quickly without really giving the other side a full opportunity to be heard, but that was rare.
What would happen in a situation, I'm going to now go back to your experience as a trial judge, where you issued an order of protection and there was a violation? What did you do in those circumstances? Now in the civil side, actually both civil and criminal.
Well, so for criminal, the person is likely to have been arrested. And I saw so many of those. So they're told to stay away and they just can't. We all know who work in this field that the reality is sometimes the victim has said it's okay to come over, but the perpetrator is told it's not the victim's order, it's the court's order, and whether he or she says you can come, don't go. But often, more often, the person just can't stay away, wants to see the children when they haven't been permitted to do so, and they've been arrested. And then, the question is, do you set bail or not? Obviously, with bail reform, there's less bail being set on those. On the civil side, you do have the power to order someone incarcerated for contempt or violation of a court order. That was not the first option. The first option is to try to get the order followed. And maybe you put some additional conditions on it. Maybe you give them a warning. Again, it sort of depended on the severity and also what the complainant is asking for. So mostly in my experience, the complainant just wanted the order complied with. They did not want the person in jail. And so you try to work with the attorney for the perpetrator to see what is getting in the way of compliance.
And just for clarification, if you issue an order of protection, the victim, the person who you're benefiting with this order, can contact the perpetrator, right? Because the order of protection is against the perpetrator. They're not allowed to contact the victim, but the victim can contact the perpetrator. So what happens is the victim then contacts the perpetrator, and sometimes it's reasonable. It can relate to the children. And some of these orders actually have what we call in the industry carve-outs, meaning a carve-out, an exception to the order of protection that allows for communication relating to the children. But let's just say the communication from the victim to the perpetrator had nothing to do, it wasn't related to any sort of carve-out, was just a communication, maybe make sure you pay the mortgage, or, you're a jerk, or come over, whatever it is, and then the perpetrator responds, but that's a violation.
Right. If it's come over, it's a violation. I would never have issued a contempt order for the person who got the message that says, please pay the mortgage, and writes back, I paid it. I mean, it has to be a willful and intentional violation of a court order, and judges have some common sense. But sometimes what happens, more often than you think, is the complainant says, come over, the kids really want to see you, it's Father's Day, let's take the best case. And he comes over, and they're having a nice time, and then suddenly he starts to get angry and says, why'd you get this order of protection, and picks up something and throws it. So that's clearly not permitted. She didn't invite him over to throw something. And actually what I saw often is that scenario. Very rarely did I see, criminal or civil, a contempt for the person who just happened to be there. It was they were there, and then the fighting broke out. And as I said, statistically, often it's the neighbors or the landlord, because you do hear the thud or the yelling or the screaming, and people are, even in New York City, where I think people think no one gets involved, there's a surprising amount of involvement when somebody hears something next door.
Let's talk about your role for Sanctuary for Families.
Sure.
In my experience, Judge, it's so rare for somebody like you who has served on the bench, who was an elected public official, to then, now that you're no longer on the bench, to actually do this kind of pro bono work, which is such difficult and important work. Thank you, Judge.
Thank you.
So what is that like? And, well, I guess first question is, why are you doing it?
I became a judge at a very young age for being a judge, and I was fortunate enough to do it for 30 years and fortunate enough to still be able to do something else. And I wanted to give back. I primarily, though not exclusively, but I primarily handle cases involving financial issues. So I don't do criminal cases at all. I only do civil cases. And a lot of the cases I do are for sanctuary clients who already have been awarded support or property distribution and somebody stopped paying. And these are cases, again, not all I do, but a lot. And these are cases for which the court system does not appoint lawyers. So these litigants basically have to represent themselves or find pro bono work. And I knew from my years as a bench that this was an area that was it's hard even for someone with my experience, but for someone to navigate this system without a lawyer, very challenging, and my firm is very generous. Let me do it. And I also run an externship at Columbia Law School where I have some law students who are handling these cases as well. So I wanted to do something interesting, and it certainly is.
What is Sanctuary for Families? What organization is that?
So Sanctuary for Families is one of New York City's largest nonprofits that provide a range of services to domestic violence survivors and their children. It's actually led by Judy Kluger, who I knew from when I was a prosecutor. Then we became judges together. Judge Kluger was one of my early supervisors, and so that's also what led me to Sanctuary, because I knew of her leadership. They provide a range of services. They have an intake and helpline. They do family cases, immigration cases. They run some shelters in New York City. They have a employment sort of training program. So it's really a multi-service center for these kinds of cases. And they have a special unit that does divorce and economic cases. And that's sort of where a lot of my pro bono work is.
Judge, what would you tell victims of domestic violence? Now, this is a hard question to answer, and it's a broad question, but what would you tell victims who are listening to this episode, who are scared? They're not in courts yet. They're in a relationship. They're scared. They don't know what to do. They want to get out of their bad relationship. What can the courts do for them and not do for them?
So the first thing I would say is call someone. Call Sanctuary. Call a group called Safe Horizon. There's a New York State domestic violence hotline. Go on the internet, Google, Safari, whatever you use, New York State domestic violence help, and talk to someone. It's an overused phrase, but you are not alone. And everybody's situation. And then there are people on these hotlines who will come up with a safety plan. That's the most important thing I can tell people. Figure out how to do this safely. And then, if you can afford a lawyer, find one. There are some terrific lawyers who know how to do this. If you can't afford a lawyer, talk to one of these agencies. They may be able to provide you with legal help at no charge.
Judge, do you think that the courts are effective? And I think I know your answer as a jurist for so many years, but I do want to ask the question. Do you think the courts are effective in addressing these issues both in terms of ensuring the safety of the victims and also keeping the matters fair in terms of allowing the perpetrators to tell their story as well. Do you think the courts are doing a good job addressing these cases?
Yeah, obviously I do. I think justice moves slower than people would like. Probably moves slower than judges like because of the volume of the cases. The state legislature just approved additional family court judges, and I think that will go a long way once they are sort of settled, trained, and, ready to go to addressing some of the backlogs. COVID was a real challenge in the court system, and the courts I can see as a practitioner now are still recovering from the backlog. The courts were not set up. There was no such thing as a remote proceeding, and when there couldn't be in-person proceedings, everybody suddenly had to figure out, oh my goodness, what do we do? Now they're set up, and I'm really starting to see things moving. I think there is a perception that the system's not fair, but I don't think it's a reality, and I think it could always improve, and there's lots of training going on to make it better.
Are you involved in some of that training?
Not anymore. I was when I was on the bench, but most of it now is done by active judges, although organizations such as Sanctuary, they ran a very large conference in the fall in which a number of judges attended. I think just raising awareness and maybe trying to attack some of the myths that have come up on this podcast.
Judge Richter, thank you for appearing as a guest on our podcast, Was Justice Delivered? We're so honored to have you on this episode.
Well, thank you. Really, it was a pleasure, and I really appreciated the conversation. It was very interesting.
Listeners, thank you so much for tuning in. Thanks, Judge. That was great. People are so lucky to hear from somebody with your experience.
Well, thank you. And you had such good questions.